I have an article in front of me about Rupert Murdoch. A lot of these celebrity cases I do, well, somebody's already died, and this is sort of an estate crossover, although Rupert isn't dead. But this article really goes into a trust dispute, even though the grantor of the trust, Rupert, is still living. This article comes from the New York Times, and there are actually a couple of articles about it. And what's really interesting about the New York Times is they somehow got hold of sealed court documents. By default, court records are public record. I can go online to some database and pull just about every court record unless they're sealed. And we see sealed records oftentimes dealing like with minor children. That's a really common sealed record case. So it's actually fairly unusual to see a sealed record case dealing with the trust. But at any rate, here we have a sealed record case dealing with Rupert Murdoch. Now, first of all, we have some pretty high-level issues going on here. Even though Rupert's 93 years old, he's still in the thick of it. He's still, in the trenches, getting after it. And here he is, 93 years old, and he's involved in a dispute with his own family here in court. Rupert has this irrevocable trust, right? And an irrevocable trust means that it can't be changed. So the other main type of trust is a revocable trust. But in order to still be considered an irrevocable trust, which normally you can't change, that's what an irrevocable trust is, he gave himself this little sliver of, the power to amend, but he had to go through court. Hence this case. And what the judge is trying to determine in this particular case is whether or not Rupert has the power to make this small change in good faith. So he's asking, Rupert is petitioning the judge to make a ruling that his requested change is done in good faith and not in bad faith. Because if it's done in bad faith, the trust document says it's not allowed. If it's done in good faith for the benefit of his family, then it would be allowed. And so these high-powered lawyers are arguing in court, yeah, the change that Rupert wants to make is good faith. No, that's crazy. This is totally bad faith. And really what he's trying to do in this case is say that among those 4 children, when Rupert passes away, just one of the children should be the trustee. And of course, the trustee is the person who has the power. They have the ability to manage whatever assets are in the trust. And if you're not familiar with Rupert Murdoch, his family owns a lot of media enterprises like Fox News and a bunch of newspapers and things like that. So Rupert, his high-powered attorneys argue in court, look, the family media has often been conservative. It's not been the more liberal mainstream media. This has been the more conservative media. And if the trust is left like it is, this media empire after I die isn't going to be conservative enough. So there's just one of the children, he argues, if they were appointed as trustee, that one child would be more conservative. And in his estimation, that would be more successful. So he says, yeah, this change to make it just this one kiddo as the trustee is a good faith change because that one kiddo tends to be more conservative. And with history as a guide, that's paid off really well for this media empire. Being more conservative will put more money in the pockets, i.e. good faith. Now, of course, the other 3 children say, wait a minute, you're limiting our power? How could that be in our good faith? And, maybe being more balanced would not be bad for us. So, they argue that maybe it's not good faith to make this change. Now, this is a case that is actually ongoing right now And, given the fact that Rupert is 93 years old, this dispute may actually last until after he passes away because, billion-dollar estate disputes typically don't get resolved overnight. And the fact that all these high-power attorneys are involved, they're not inexpensive. They have their own vested interest in continuing the case for a long time. This one may drag out, and this may be a knockdown drag out for some period of time. Let me just shift gears just for a second and put on my hat as an estate attorney. Now, typically when we have these situations where we're going to have multiple beneficiaries, it's not going to be my recommendation to have multiple of them serving as trustee. So in the current version of Rupert's trust document, keep in mind, the 4 of them are in charge. Now, that wouldn't be my typical recommendation. A lot of times I kind of use the example, that's like asking 4 people to do one job. That's actually a lot harder than you would think. If you all 4 are fiduciaries and you all 4 share responsibility to do the right thing, well, you might reasonably differ in your opinion about what the right thing is, particularly when you're dealing with really complicated things like running businesses. So apparently what happened is the way that these 4 all kind of got put in charge upon Rupert's passing was based on a divorce settlement of Rupert's from back in 1999. And his ex-spouse kind of, as part of their divorce settlement, got this arrangement where when Rupert died, all 4 of them, all 4 of the children would have equal power. Although that's generally not a great idea. So I do think that there is sort of a plausible argument here to have just one of the children in charge as trustee. Although I also have to say a lot of times what we would do in this situation is say none of them should be in charge. It's not great to have 4 of them sharing one job because that can end in disputes, but also it's not a good idea to have just one of them in charge because they might not be doing a very good job. They may be a little too conservative. They may be a little too radical in their thinking, and maybe it's not in the best interest to have just that one cook in the kitchen. And so a lot of times what we might say is, it's actually worth it to have a professional. A professional is going to come at a cost, but professional fiduciaries have done it before. They have been a trustee before. They have their own team of attorneys. They have experience. They know what they're doing. So what's interesting to me in this case is that, Rupert is sort of caught between 2 really difficult, options: to have the 4 kids serve as co-trustees, which is not awesome, or to have just one of the kids serve as trustee, which might turn out fine, but that actually might also not turn out fine. And so, a lot of times in a similar situation, we would just say, hey, why don't you have a trusted professional or trusted team of professionals who are neutral, who don't have a horse in the race, but have a proven track record? Why don't you let them do the job? Because odds are they will have more success. Like I said a minute ago, this is an ongoing case. It's actually playing out in Nevada, which Nevada has sort of better privacy laws. So you'll see a lot of these trusts that are sort of based in Nevada because of the enhanced privacy laws that they offer there. And so this case may take a while to play out, but I may do another video at the conclusion of this to see who wins. Will all 4 of the kids remain as co-trustees? I.e., was it a bad faith change to make just one of them as the trustee? Or will Rupert Murdoch get his way, and will it be his one preferred son who will get to serve as the sole trustee after Rupert passes away? I don't know. It'll be interesting. I can see the arguments on both sides, and I may do another video as an update once this case gets wrapped up.